Hi, my name is Neil Good. I'm with the Good Law Group, and today I'm going to be talking about attorney fees and costs at the administrative level. This is not going to be anything to do with going to federal court. So there's two parts to payment of an attorney at the Social Security Administration. The first part are the fees, and that's what they get paid for the work they do. And the second part are the costs. So typically costs are costs we advance on behalf of a client, and those get paid back. We only charge those if we win. We don't charge those if we lose. And those could be, typically are the medical records and any reports from doctors. And sometimes testimony of a doctor if we advance the cost for testimony of a doctor if it's necessary. Then the costs are, and this is the Social Security rule, right now it's 25% of the back pay with a cap of $6,000 through the first hearing level. So with Social Security, if you lose at the first hearing, you can appeal to the Appeals Council. And if you win at the Appeals Council and they give you a new hearing, then the 25% cap is still there. The $6,000 cap is gone though. So what happens is the attorney would have to file a fee petition. So the way the contracts typically read is the attorney gets 25% of the retroactive pay through the administrative law judge hearing with a cap of $6,000 plus costs. And costs are completely separate. Okay, so how does the 25% of the retroactive pay work? So first of all, it applies to both SSI, Supplemental Security Income, and SSDI cases. SSDI being Social Security Disability Insurance. The attorney gets paid 25%, but not more than $6,000. So let's assume that the monthly benefit is $1,000 a month. And realize with SSI, the monthly benefit starts immediately upon the application if the judge rules in your favor. With SSDI, there's a 5-month waiting period from the date the judge determined you were disabled from. But we're going to just talk about payments. So let's assume that the monthly payment is $1,000 a month and you win the case and there's 12 months of back payments. So the attorney would get 25% of that, or $3,000. Now let's assume that the attorney wins the case after 24, and there's 24 months of back payments. So the back pay is $24,000. So the attorney would get paid 25% of that, or $6,000, and that's the current cap. So they move the cap up and down, but right now that's the cap. Now let's assume it takes 36 months to win the case in front of a judge the first time. The client would get $36,000. 25% of $36,000 is $9,000, but that's above the cap. So the attorney would get $6,000. So you can see how at the 24-month or the 36-month, the attorney gets paid the same amount of money. So there's another way to kind of look at this calculation, and that is if somebody's getting $2,000 a month in back pay and you win the case in a year, then that attorney would get a $6,000 pay in a year. The other part of this is that, let's say you lose at the first administrative law judge hearing. Most of the contracts say that the cap is off and it's up to 25%. So let's assume that you lose at the first administrative law judge hearing. The lawyer appeals to the Appeals Council. You win at the Appeals Council, they remand it for another trial, and that takes another year. The attorney would get 25% of the back pay, but to get this, he has to file a fee petition. So the point is that if you win after the administrative law judge hearing, the first one, and you have to go to the Appeals Council, you win at the Appeals Council, or you win at a second hearing, then the cap of $6,000 is off. Thank you for watching the video today. I hope this was helpful. I know it's a little bit confusing. If you have any questions or we can help you with a Social Security disability case, please reach out to us at the information below. Thank you.